The format for today is going to be myself and Kim. On our next slide, there we are. Back in the days when I had more hair, and Kim, who of course still looks like that because that's what happens with young people. They just stay looking young. And we're going to be looking about what the decisions say in each case, the pros and cons of them, and then exploring some of the consequences that there are from these decisions. This is fairly rapid. We've got half an hour to try and cover all these things. If there are questions as they come along, please do feel free to stick them in the chat box, and we'll try and pick them up. Or failing that, we'll deal with them in writing at the end. So, Kim, over to you. Tell me all about the Gala Unity case.
Thanks very much, Justin. So I'm just going to give a quick overview for any of you who aren't familiar with the Gala Unity decision. I'm assuming if you've tuned in that you've probably got some idea, but just a quick refresher. So this was a case that was all about 2 blocks of flats in Swindon. And these blocks were on an estate, which, as well as the 2 blocks of flats, consisted of 2 coach houses, they're referred to in the decision, which are essentially a first floor flat with some parking spaces underneath. And those coach houses, or the leaseholders of the flats above the coach houses, did not participate in the RTM claim, but the leaseholders of the blocks of flats did. There were also areas on the estate that served both the coach house lessees and the block lessees, such as the dustbin store and their communal access ways, etc., that you would find on a shared estate. Now, in the first tier tribunal said, yes, the blocks could claim the right to manage without including the coach houses. And similarly, the upper tribunal agreed, dismissed the appeal, and the landlords went up to the Court of Appeal. And so the Court of Appeal, for the key issue there, was to what parts, if any, of the estate currently managed by the management company of the freeholders, did the right to manage company's right to manage extend? Did it just extend to the 2 blocks, or did it also extend to the communal parts shared also by the non-RTM coach houses? And the upper tribunal and the Court of Appeal both agreed that it extended beyond just the 2 blocks themselves to all appurtenant property, and that included property over which the leaseholders of the coach houses had rights, and despite the fact they didn't participate in the RTM claim. So this prompts some issues in relation to shared estate management and who manages these communal parts. So Justin and I are now going to have a debate over whether that's right or wrong. And for purposes of this webinar, Justin is in favour of Gala Unity and I'm against it. So over to you, Justin, on why do you think the Gala decision is correct?
This is proof that barristers will argue anything if you give them money. The best way of approaching Gala, seems to me, is to go back to the Act. And there is no doubt that the blocks in Gala are self-contained blocks. There's no doubt that physically they qualify, and there's no doubt that in terms of the number of leases in them, and in terms of all the other qualification conditions, no Schedule 6 exception applies. There's no question that each of these blocks is intended to apply. There's also, it seems to me, no question that the right to manage extends to a pertinent property, at least at some degree. It's impossible to argue it wasn't intended to apply to any pertinent property. It would be ludicrous to suggest that you only got to imagine you had a situation where a building has its own grounds and there's no sharing going on. Those grounds are appurtenances. It'd be ludicrous to suggest that you only got to manage your own building and not your own exclusively appurtenant grounds. So the argument for the landlord in Gala really means reading in a number of restrictions that aren't there on the face of the legislation. It means reading in either that that appurtenances in the Act only mean exclusive appurtenances, or, slightly more cunning way of putting it, albeit to the same effect, it means reading in some kind of requirement that you don't get incorporeal rights under the right to manage legislation. So you don't get anything to do with maintenance of rights of way or rights of parking or anything like that. And there's just no basis for that kind of restriction on the face of the Act. It may or may not have been sensible to create such a restriction, but there isn't one. To the contrary, if you go and look at the definitional provisions in section 112, all it says is it's an appurtenance if it's usually enjoyed with the building, part of the building or the flat. It's got nothing to do with whether anybody else benefits from it. Now, look, there is a. I mean, you're going to come back.
Yeah,
I know.
Counter arguments.
But you're going to come back, and you're going to come back with the best point. And the best point is that shared management of appurtenances creates a problem. And the answer is, well, it might. I mean, it may not in any given case. You don't actually know that. It's always possible for agreements to be reached. But even if it does create problems, in no other field do we ban dual management. I mean, it'd be perfectly lawful for a developer to set up, build a development, 3 blocks of flats, 3 embedded management companies, and you could make each of the 3 of them responsible for the whole of the common parts if you wanted to. There's no law against it. The fact that human nature being what it is, people might fall out, is not a reason to constrain their rights in the first instance. So there you go. What's wrong with it?
So I think the most important thing that's wrong with it, and let's bear in mind that we're sort of dealing with what should the law be in an ideal world. I think here the thing that's wrong with Gala is that it simply doesn't recognise, and potentially because of the facts of that case being a relatively contained estate where only 2 small parts weren't involved in the RTM claim, it just doesn't really consider the wide-reaching repercussions of that decision. And this isn't just a case of 2 parties trying to reach an agreement. There's a potential for that there are 2 parties who are still liable to their lessees to carry out the same management functions, and if they can't reach an agreement, that leads to both of them potentially carrying out the works. That leads to duplication, wasted costs. How do you claim the money back? And I think those practical consequences were recognised by Martin Roger in the Fencott decision that you've got there that's up there on the slide. But also, I think they really come to the fore in the subsequent case, which is in a later case of Settlers Court, which is an upper tribunal decision saying that Gala is right. It wasn't per incuriam and applying it. But when you look at the facts of that case, this is a much bigger estate. It's the Virginia Key development. It's a huge estate. You've only got 1 block that's exercised the right to manage. And the communal estate services cover all sorts of things, from maintenance of a river wall to gardens to massive areas that you couldn't possibly expect a right to manage company to actually be capable of carrying out. And I'm sure that wasn't their intention when they exercised the right to manage their block, but they were going to suddenly find themselves responsible for all these quite significant communal estate services. So I think that's something that the Gala Unity decision just doesn't factor in. And alongside that is the fact that the Act, okay, on the face of the Act, you can take the reading that the Court of Appeal did in Gala, but there are other readings available, and surely you have to take into account the significant practical consequences of a very strict interpretation and actually apply potentially a more purposive one to avoid some of those issues. And worth noting that in Gala, the court didn't say that the freeholder loses the responsibility, and perhaps worth just going back to the Act briefly here for anyone who's not hugely familiar with it. The Act provides that once a right to manage company has exercised the right to manage, the landlord can no longer provide the services which the right to manage company has to provide for the leaseholders who participated in the right to manage claim. Now, the landlord remains responsible for providing those services for the non-right to manage leaseholders, but that's where this sort of dual management issue comes in, and they can't collect service charges in respect of the costs of providing those services from the RTM leaseholders. So you're suddenly effectively responsible for providing the same level of service but to a smaller group of people, and only being able to charge back to a smaller group of people, which can create problems, especially if you don't have an ability to redistribute potentially the proportions of the service charge that you're regaining, which was an issue in a case I did recently. There's all sorts of practical issues, and I know that that's not necessarily a reason to for the Court of Appeal to read the statute differently, but we're hoping it's one for the Supreme Court, that the Supreme Court will take into account if they decide to allow the Settlers Court decision to go up to them and look at this again.
I mean, Kim's too modest to mention this, but she's junior counsel for the landlord in the Settlers Court one, where they're arguing that Gala Unity is wrong and they want the Supreme Court to overturn it. But look, you've just told me there are all these practical difficulties, and The difficulty with that, though, for the purpose of this slightly academic debate that we're having, is the Court of Appeal did know about that in Gala Unity, because Sullivan at the end says, "I've read the judgment of the then president of the Lands Tribunal, and he identifies there are these problems. So what? The legislation is clear." I mean, your point is really that because people didn't really hammer home how bad these problems were, neither George Bartlett nor the Court of Appeal really understood quite what they were doing. But they did appreciate that there would be a problem of management. They just said, so what? That's what the legislation says. I mean, what's wrong with that?
I think it's not necessarily what the legislation says. So I think there are other ways of construing what a pertinent property means within, and still staying within, the clear wording of section 112. So a pertinent property doesn't necessarily have to extend to claiming property over which other people also have rights. Why couldn't that just be limited to rights that only the RTM leaseholders have? Or could self-contained, the definition of self-contained, be read in such a way as to limit which property the RTM leaseholder, the RTM company, acquires rights over? So I think there were alternatives, and I think perhaps on the facts of that case, they didn't necessarily see the need to consider those in the detail that they should have done. So basically, I think what I'm saying is that the Court of Appeal got it wrong, and they could try again.
But it goes both ways, though, because if you introduce some of the restrictions that you're proposing introducing, so say, for example, say the law was that you only got the appurtenances if they were exclusively appurtenant to your block. Landlords, being what they are, and I say this as someone who acts for lots of landlords, will therefore find a way of scuppering the right to manage, because what you do is you create an utterly pointless right of way over the gardens in favour of another block on the other side of the estate, and so there you go. That means you can't RTM the estate functions at all.
But why do you need to? I mean, why not? Isn't the whole point of right to manage that you get to manage your block? I mean, we'll come on to this, I suppose, in Triplerose. It feeds into that debate. But do you need to be able? Was the right to manage designed to let you manage the wider estate?
Well, I mean, that's a more difficult question you get into in Triplerose. Whether it was designed to or not, you get, the way the case law has gone is that you are intended to be in the same position as the landlord. The landlord gets to manage both. Why shouldn't the leaseholders?
Mm.
I mean, what would happen? I don't want to spend too much more time on this, but yeah. All the problems that you're identifying, they're not exclusive to right to manage. You could have the same problems arise if you start enfranchising individual blocks on an estate. Now, the 93 Act has a slightly better way of resolving all this, but the same problems could still arise. I mean, isn't the real reason that landlords make a fuss about this is because, unlike 93, they're not getting large amounts of money in exchange for the transfer of functions. And if landlords were getting large amounts of money, might they not well take a very different view to this?
I don't think that's fair. I mean, of course, there are always going to be certain cases where maybe this is all about, it is all about money for the landlord, but there are also going to be cases where you have landlords who are very serious about complying with their obligations under leases to provide estate management functions, and simply are being precluded from doing that in cases where one block has exercised the right to manage. And I mean, that's the case in the Settlers Court decision. They're losing money, quite large sums of money every year, because the block that has exercised the right to manage is refusing to pay a contribution towards the vast service charges which are required to manage this very complex estate. And why should landlords be put in that position? So perhaps it is about money from a different side, because at the end of the day, they've got to run a viable business, and they've also got to provide these services, and the money doesn't come from nowhere.
Just one question before you do, because I'm sure people listening to this, rather than hearing us go on, will want to know, where's Settlers Court got to? Because you in the upper tribunal, you and Simon ran the argument that Gala Unity shouldn't be followed as per incuriam.
Yeah.
And Siobhan McGrath says, no, it's not per incuriam.
Yes. So
what's happened to it after that?
We applied for what's known as a leapfrog certificate that allows you to go directly from the upper tribunal, the High Court, to the Supreme Court on the basis that if it's not per curiam, then the Court of Appeal will be bound by it effectively as much as the upper tribunal was. So the only way to change this decision is to go up to the Supreme Court. And Siobhan McGrath accepted that, and she granted us our leapfrog certificate. Unfortunately, the way it works is you then have to apply to the Supreme Court for permission to appeal, so you don't get in directly from the upper tribunal. So we've put that application in, and we're just waiting to see what happens next.
Do you know what stage that's at?
We don't. We've not heard anything yet.
And so, presumably you did all this just before lockdown.
We did. So
it's no doubt. So it's now in the very well heeled backlog of cases in the Supreme Court.
Yes, unfortunately so. But,
yeah,
watch this space.
Okay.
Shall we move on to Triplerose?
Yeah, go on then.
Justin, do you want to tell us a bit about what Triplerose is all about?
Yeah, there's not really an awful lot to say about these cases. What you had, well, it's not true. There's a lot to argue about, but there's not a lot in terms of factual background because the facts don't really matter. In the lead up to the three cases that were known as the Triplerose cases, you'd had a number of different first-tier tribunal cases coming to different conclusions on whether or not you could have an RTM company managing more than one block. And if you could manage more than one block, the ancillary question was, how did you do it? Was it one claim notice or was it a separate claim notice for each block? So in the Triplerose case, two of them were appeals from the first-tier tribunal and one of them was just transferred straight into the upper tribunal. It's quite a useful power for any of you who are listening. If you've got really interesting work that's obviously going to go on appeal, you can skip the FTT by just asking for it to be transferred straight to the upper tribunal. So these three cases are in the upper tribunal. Although the number of buildings in them is different, for present purposes, all you need to know is that there are multiple buildings on estates. There is one RTM company for each of the three estates, and it's trying to claim the right to manage through one claim notice in each case. And the question for the upper tribunal is just, well, can you do that? And the upper tribunal says yes. They say, as long as each building meets its own qualifying conditions, then there's no reason why one company can't manage each of the separate blocks. So as long as block one is a self-contained building or part of a building with the requisite number of leaseholders and the requisite number of members of the company, and block two and block three, then you can have an RTM company called blocks 1 to 3 RTM Limited, and it can do everything. And part of the attraction for that is that's a pretty good way around the Gala Unity problem, because you take over the whole estate and then there's none of the shared management functions that you were concerned about, Kim. Now, the landlords appealed that to the Court of Appeal, and the Court of Appeal overturned the upper tribunal. The Court of Appeal say that the language of the Act is singular. It's about conferring on the leaseholders of a block the right to take over the management of that block. The safeguards in the legislation don't really work if you start doing multiple blocks. So, for example, you could have a situation where a big block of 100 leaseholders and a small block of 10 leaseholders are in the same company. How do you safeguard the rights of the 10? And then, thirdly, they say there's no principled way of drawing a distinction between an estate and just wholly unconnected buildings. So if you can have an RTM company for more than one building, where do you get the idea from that they've all got to be on the same estate or somehow connected? Because that's not in the Act. What would stop you having an RTM company for a block in Liverpool and a block in London? On the face of the legislation, nothing. So they overturn it. It's fair to say this is one of the more controversial decisions. Those of you who are following the Law Commission's work will see the Law Commission has come up with some incredibly complicated ways of trying to overturn this decision. I say this as someone who worked on the Law Commission proposals. They are really complicated to try and allow multiple blocks. But Kim, go on and convince everyone that the Court of Appeal was right and the Law Commission is wasting its time trying to overturn this decision.
Okay. Without causing any offence to anyone in my old Law Commission team, let me go have a go at that. So again, I mean, I think similar to Gala, you've got to look at the face. You've got to look at what the Act says, and the Act is clear that it only applies to a self-contained building or part of a building, and that if essentially it all turns on that word a, you know, that it's a self-contained building, it's not multiple. So that's the starting point. And then you follow on from that and you look at other parts of the Act, so sections 73 and 74 in particular, but they don't allow for leaseholders of a certain premises A to be members of an RTM company for premises B. So if you've got leaseholders from both trying to form an RTM company, that just doesn't allow for it. The Act was obviously not designed with that in mind. Again, and then coming to the purpose of the legislation, well, the whole point, and this kind of comes back to one of the points I was making on Gala, is that it was about letting leaseholders take control of their block. If you get back to letting one RTM company take control of a whole estate, then you've still got someone sort of sitting above the leaseholders, and you don't have that direct control that the legislation was intended to give people. And then there are various other, you know, if you look at the regulations that are passed under the Act, so the RTM companies and model articles, England Regulations 2009, I'd recommend those, they're a good read. Those are wholly inconsistent with the idea of an RTM company acquiring the right to manage multiple sets of premises. It's all about the premises, the self-contained building or part of a building that's involved. There are also practical problems, as Justin said, which were argued by the freeholders in this case. So what does happen when you've got two very different sized blocks and you've got an RTM company that has acquired the right to manage in respect to those, and then the larger block is obviously going to dominate. You're going to have more leaseholders with more shares or more voting rights. It seems to we've lost Justin temporarily, but I'm assuming he's going to come back soon, so I'm going to keep going. You've also got potential for conflict of interest, because not all blocks are necessarily going to share the same views. And that, again, this comes back to this idea that the whole point is to give leaseholders control. Oh, hello. We've got a new guest who's going to, I'm sure, argue against me very, very strongly on all of this.
Going to add his comments in a bit.
Brilliant. I'm glad to see. And also that, you know, I've gone into the statutory purpose, but you actually don't need to go that far to get to this conclusion. The wording is clear. Why would you go against the fact that a self-contained building is clearly a self-contained building?
If the Elim court case had happened before Triplerose, I think the result in Triplerose would be very different. Because Elim court tells us that we're supposed to take a pro-leaseholder, empowering them approach. And what's empowering about stopping people from working together to manage the estate collectively in their collective interests? Nothing in the Act prohibits the idea of a multiple block RTM company. You can always come up with extreme examples that will try and show that a particular scenario can't have been contemplated by the Act. That's what lawyers do. But what practical purpose is achieved by forcing people to set up different RTM companies and then forcing those companies to set up an umbrella company to do the estate, which is what's suggested in Triplerose, or to make them all have the same managing agent or whatever it's going to be? I think there's also a point that prior to Triplerose, the majority of the FTT cases had been in favour of multiple blocks. And as we'll look at in a minute, that creates a bit of a tactical is the wrong word. It creates a management problem for those older blocks, older estates that were pre-Triplerose RTM.
Yeah.
So ultimately, what's wrong with it? I mean, we all know that A in legislation can mean singular or plural. We all know that Interpretation Act lets you have it lets you say the singular includes the plural. Ultimately, the Court of Appeal was persuaded by the possibility of extreme scenario disasters. And why is that the way to drive legislation? Why is that the answer?
Yeah, I think another point that I didn't put in sort of my first round of arguments also that I think they're trying to maintain some consistency perhaps with the 1993 Act and the enfranchisement legislation, which also says you can't enfranchise multiple blocks. multiple self-contained blocks at the same time.
Yeah, but you shouldn't. But you shouldn't have 93 driving this forward. They're doing different things. One's about a compulsory transfer of title, and the other's just about who paints the corridors.
I think they all stem from a similar unease about tenants not having sufficient control over the management of their blocks, and management is a huge part of that. In the end, tenants who want the freehold part of it is normally driven by wanting to have better control, and that stems from management or thinking that this will be managed. I'm conscious of the time. Should we move on?
Let's do the last slide.
One, which like as Justin's already mentioned, the issue is what happens to all these blocks, including. Sorry, I'm struggling to get onto the next slide. Including the Gala Unity allowed for 2 blocks to have the right to manage by a single RTM company. So what happens to all of these blocks now? Now my stance on this, at least for the purposes of the present webinar, is that these are still valid, and you have on that there's no direct authority. I think it's fair to say there's no direct authority on this either way. But there's some overture comments from the upper tribunal in the Allen Court decision that you've got up there on the side. But essentially, that in order to dispute a right to manage claim, you have to serve a valid counter notice. And if you don't serve a counter notice, or you serve a counter notice admitting the claim, then it's all automatic under the Act. You get the right to manage company gets the right to manage, and it's all hunky-dory basically. It goes, there's nothing you can do about it at that stage. So no, and if you serve no counter notice, then that's it. And in a lot of these cases, no counter notice was served, or a counter notice was served admitting the claim. So how do they get around that?
Because it can't mean that. If I serve a claim notice on London Zoo, and London Zoo throws my claim notice in the bin because it's London Zoo, that does not mean that on the date specified in my claim notice, I get the right to manage London Zoo. I mean, that would make my son very happy. Now he's wandered off, can't be talking about him. He'd be ecstatic if I managed London Zoo. He would regard that as a much more valid career choice than being a barrister. However, the mere fact that you don't respond to a statutory notice cannot mean that the other person gets the benefit from it if the thing did not qualify in the first place. And I mean, you get hints at that from the Regent Court case that I lost, and St Stephen's Mansions case that I lost. If it just doesn't qualify, and it doesn't qualify because the Court of Appeal says it doesn't qualify, how can it be a right to manage company?
Okay, sorry.
I mean, what's the answer to that?
Yeah, well, what do you do about it, Justin? I think let's add that in for good measure at the end, because if you aren't within the RTM regime, then how do you get in front of the tribunal?
Oh, I don't think you can get in front of the tribunal. I think you've got to go off to the High Court and get declarations. I've done that once. A case down in the Cardiff District Registry where someone had RTM'd a block, or an estate with multiple blocks on it. The then landlord hadn't done anything. We'd bought the reversion. Triplerose had come out, and then we'd said, look, what are you doing? You can't be an RTM company. It's impossible. So we ran that in the High Court, and we got our declaration. Depends what you want to do. In that particular case, we just wanted to regularise it. We were quite prepared to let them set up proper companies, serve notices, and we'd let them go through. We just didn't want there to be any regulatory black hole.
Yeah.
Because one of the buildings had structural problems. It needed someone to do work on it. We didn't really care if it was them or us. What we didn't want was the local authority serving a notice on us and us saying, what do you mean there's an RTM company? And then saying, no, there isn't. So I think if you want to have the fight, you go to the High Court. What you do about it depends upon what the position of the landlord is. Mm. It is possible for landlords to use this to get their properties back. I do think that is true. There can't be any question of estoppel because you can't be estopped into a jurisdiction that doesn't exist. There can't be any question of agreement because you can't agree an act applies when it doesn't.
Is there a risk that landlords have been found to be in breach of, or if you then basically admit that you've been in breach of your covenants for years and years of services that you should have been providing, that you've been letting someone else provide? Yeah, I think, and that's why I think landlords who've got multiple block ones need to regularise it. It's not so much the covenants and the, I haven't been providing the cleaning when I should have done. The one that worries me is the service charges. Mm. Because someone who has no right to the service charges has been holding them for quite long periods of time.
And given that service charges are on statutory trust, that's probably a bad thing to have someone who's got no right to the money holding it. I would have thought if you had a good relationship with the RTM company, the answer post Triplerose was get them to wind themselves up and then agree that what they do is set new companies up and you wouldn't oppose it. But if you wanted it back, I think you could have gone to try to get it back, certainly.
Right.
So, I mean, what's interesting is there have been so few cases about it.
Yeah.
I mean, you've got one, maybe, winding its way through. I've done one. I've heard stories of one or two others, but I'm surprised it hasn't been litigated in a more extensive forum.
I agree.
So,
well, on that note, I think we're at the end of our half-hour slot. I haven't seen any questions on the chat, so I think we've lost everybody. But
yes, I'd probably better go and deal with someone who was expecting to be provided with ice cream some time ago.
Okay. Well, please tune in to the next one of these. It's not with Justin and myself, but with others, members of Landmark, on the 7th of July. And thank you very much for joining us.
Thank you very much.